Hi everyone, welcome from Law with Dunk, the Law Guy, and today is day 36 of the Case a Day series journey, covering cases across criminal law, tort law, contract law, and the English legal system. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. Today I'd like to go through the case of R.V. Woollin, 1998. In the case of R.V. Woollin, 1998, after providing explanations to ambulance workers and the police, the defendant went on to eventually admit to police after a couple of police interviews that he had gotten angry and lost his cool, in his words, when his 3-month-old baby would not stop crying. He proceeded to pick his baby up, shake him, and then throw him across the room with force towards the baby's pram, which was situated approximately 5 feet away. He missed the pram and the baby hit the floor hard. The baby went on to sustain head injuries, a fractured skull, and sadly died. At trial, the defendant stated that he didn't intend for his child to die, nor thought that he would kill his child from his actions, and that he had not wanted his child to die. The trial judge directed the jury that they should convict the defendant of murder in this case if they felt the defendant realised and appreciated when throwing the baby that there was a substantial risk of serious injury. If this was the case, the trial judge made it clear that each juror would be open to find that the defendant intended to cause injury to the child. The jury went on to find the defendant guilty of murder and rejected a provocation defence. The defendant appealed on the basis that with the trial judge using the term substantial risk when directing the jury, the judge had widened the definition of intention for murder and should have referred to the Nedrick test of virtual certainty that was established by the Court of Appeal 12 years prior in R.V. Nedrick, 1986. On appeal to the Court of Appeal in 1998, Woollin's, i.e. the appellant's, argument here was rejected. The Court of Appeal stated that there was no obligation by a trial court to use the virtual certainty test. However, the House of Lords substituted Woollin's murder conviction with manslaughter, so this would have been a further appeal, arguing that the murder conviction was unsafe, as the trial judge misdirected the jury with the incorrect test for foresighted consequences at trial. Also, the House of Lords mostly agreed with the virtual certainty test coined by the Court of Appeal in Nedrick. However, they made a slight modification to the Nedrick guidelines. The jury should be directed that they are not entitled to find, they've not used the word infer, they've used the word find, the necessary intention unless they feel sure that death or serious bodily harm was a virtual certainty as a result of the defendant's actions and that the defendant appreciated that such was the case. Here you can see that the above quote is almost exactly the same as Lord Lane's direction in Nedrick. However, the word infer in Nedrick has been substituted with the word find in Woollin, which poses a major problem. The problem, and therefore the mistake made by the House of Lords here in R.V. Woollin, 1998, is that the virtual certainty test is not supposed to automatically mean that the defendant has an indirect intent, as this is for the jury to decide in a Crown Court trial, not a judge. The judge is the decider of law and the jury are the deciders of fact. That is the split function that is performed between the judge and a jury within a Crown Court trial. The virtual certainty test is supposed to be a legal test to prove foresight of consequences, which is strong evidence of an indirect intent, which is ultimately for the jury to decide. In the Day 37 case, we'll take a look at how the Appellate Court decision in R.V. Matthews and Elaine 2003 corrected the mistake in R.V. Woollin. And that's it for today. Thank you from Law with Dunk, the Law Guy, and I'll see you tomorrow.